Hello everybody, welcome to Courts This Week on LiveLaw. I am Taniya Pandey, here with the most recent court updates for you. Let's begin the episode with highlights from the Supreme Court. Illegal construction has to be dealt with strictly to ensure compliance with the rule of law, the Supreme Court remarked while it directed the demolition of twin 40-story towers in the Emerald Court project of Supertech Limited in Noida for violation of building norms. Such constructions, the court said, strike at the very core of urban planning, thereby directly resulting in increased harm to the environment and a dilution of safety standards. The Supreme Court also confirmed the High Court's direction to the competent authority to grant sanction to prosecute the Noida officials who acted in collusion. The bench of Justices D.Y. Chandrachud and M.R. Shah said that a breach by the planning authority of its obligation to ensure compliance with building regulations is actionable at the instance of the residents whose rights are infringed by violation of the law. The Supreme Court on 3rd September dismissed a special leave petition which assailed the Allahabad High Court's order of dismissing the public interest litigation which had challenged Rule 18 of the UP Higher Judicial Service Rules 1975 on the ground that it prescribed only one minimum qualification, that is 45% aggregate for all categories of candidates, that is general, SC, ST, etc., and defeated the entire purpose of reservation. Preferred by the Samvidhan Bachao Trust, the SLP had stated that in light of the recommendations of the Justice Shetty Commission, Rule 18 of the 1975 rules was manifestly arbitrary and unreasonable, being ultra vires Articles 14, 15, 16 and 335 of the Constitution, as it did not prescribe any lower minimum qualification. The Apex Court dismissed the SLP and said that the Trust cannot challenge the High Court's order. The Supreme Court on 1st September issued a slew of directions pertaining to the rehabilitation and vaccination of mentally ill persons currently lodged in various hospitals and mental health care institutions. A bench of Justices D.Y. Chandrachud, Vikram Nath and Hima Kohli was adjudicating upon a plea moved by Advocate Gaurav Bansal seeking rehabilitation of thousands of mentally ill patients who are languishing in hospitals or mental asylums. In its earlier order dated 6 July 2021, the court had directed the state of Maharashtra to discontinue the practice of shifting mentally ill patients from medical establishments to beggar homes or old age homes, as it was contrary to the letter and spirit of the Mental Health Care Act 2017. The court directed all states and union territories to lay down a time-bound schedule for carrying out vaccination of such mentally ill patients, as well as the healthcare professionals and hospital staff associated with such institutions, within a period of 1 month. Furthermore, a progress report in this regard was directed to be filed with the Union Ministry of Social Justice and Empowerment on or before October 15, 2021, detailing the steps taken and the number of such mentally ill persons vaccinated against COVID-19. The Supreme Court has observed that the principle of equal pay for equal work cannot be applied merely on the basis of designation. In this case, the court had to examine the claims made by private secretaries grade 2 employed in the Eastern Central Railways for parity in pay with their counterparts working in the Central Secretariat Stenographer Service, Railway Board Secretariat Stenographer Service and Central Administrative Tribunal. Interpreting the 6th Central Pay Commission report, the court noticed that the aspect of disparity between the Secretariat and the field offices was a matter taken note of by the Commission itself while making the recommendations. The court observed that there would have been no requirement to make these separate recommendations if everyone was to be treated on parity on every aspect. Expressing disappointment with the adjudication of the NGT in 2 separate matters, the Supreme Court on 31st August restored an original application to the files of the tribunal and in another unconnected matter remanded back to it an appeal against the grant of an environmental clearance disposed of by it. The bench of Justices D.Y. Chandrachud, M.R. Shah and Hima Kohli was hearing a challenge to a February 2021 order of the NGT by which, as recorded by the Apex Court in issuing notice, the tribunal had dismissed an original application. The NGT bench, while disposing of the original application, had said that it did not find any tangible material to substantiate the plea raised in the application without recording any reasons for the same. The Supreme Court has observed that an employee is not stopped from questioning the terms and conditions of employment at a stage where he finds himself aggrieved. In this case, the teachers who were substantively appointed after going through the process of selection provided under the Uttar Pradesh State Universities Act had challenged the arbitrary conditions of the letter of appointment, restricting it to be on contract basis, limited for a period of 3 years in contravention of the statutory scheme of the Act. Before the Supreme Court, the university contended that since these teachers had accepted the terms and conditions contained in the letter of appointment, they could not turn around and challenge it now. Rejecting this contention, the bench observed that it is not open for a person appointed in public employment to ordinarily choose the terms and conditions of which he is required to serve, and that the employer is always in a dominating position. The Supreme Court has observed that merely because the High Court, while considering a second appeal, refers to certain factual aspects in the case to raise and conclude on the question of law, the same does not mean that the factual aspect and evidence has been reappreciated. Question of law for consideration will not arise in abstract, but in all cases will emerge from the facts peculiar to the case, and that there cannot be a straitjacket formula, the bench of Chief Justice of India N.V. Ramana and Justices A.S. Bopanna and Rishikesh Roy said. The Supreme Court recently directed the Special Judge Designated Court Ajmer, Rajasthan, to submit a report to the top court explaining as to why charges have not yet been framed against Hamir-Uddin, accused in the serial blasts in multiple Rajdhani expresses and other trains in the year 1993. A bench of Justices D.Y. Chandrachud and M.R. Shah also directed this special judge to submit a report within a period of 2 weeks on the status of Tada's special case of 1994. The directions were issued in light of the special leave petitions filed by Uddin, challenging rejection of the bail by the Special Judge Ajmer on March 27, 2019. Now it's time to go over judgments of the High Courts. The Delhi High Court on 3rd September granted bail to 5 accused in connection with the murder of Head Constable Ratan Lal and causing head injuries to a DCP during the Northeast Delhi riots that rocked the national capital last year. Justice Subramanian Prasad passed the order after reserving it last month. The court heard at length various counsel appearing on behalf of the accused persons, along with the Additional Solicitor General S.V. Raju and Special Public Prosecutor Amit Prasad. While the order was reserved in 11 bail applications filed by different accused persons in the FIR, the court passed orders in 5 of them. The Kerala High Court on 1st September held that it was necessary to obtain sanction under Section 197 of the CRPC for prosecution against public servants, and that cognizance of the offences taken against them without such sanction was bad in law. Justice R. Narayan Pishadari, while ruling so, dismissed a couple of revision petitions filed by the Central Bureau of Investigation challenging the order of the special CBI judge allowing applications for discharge filed by 2 accused in a criminal case. The court placed reliance on Amrik Singh v. State of Pepsu, wherein it was held that if the acts complained of are so integrally connected with the duties attaching to the office as to be inseparable from them, then sanction under Section 197(1) would be necessary. But if there was no necessary connection between them and the performance of those duties, the official status furnishing only the occasion or opportunity for the acts, then no sanction would be required. The Gujarat High Court on 31st August observed that depression can be classified as a serious illness, especially in the context of COVID, as it set aside the order and decision of a government college to cancel the registration and admission of a student as he failed to appear for the examination due to depression and suicidal thoughts. The bench of Justice N.V. Anjaria observed that approach of sympathy is not the rule of law, yet the law has to be benevolent to subserve the interests of justice, whether the facts and circumstances so justify and demand. The court has now directed the university to reconsider their decision to cancel the registration and undertake the exercise of arriving at a fresh decision in light of the facts and findings discussed by the court. The Allahabad High Court has denied bail to a sage accused of raping a minor girl aged 13 years. The bench of Justice Sanjay Kumar Singh noted that as per Section 2(1)d of the POCSO Act, a child means any person below the age of 18 years, and that in this case, a heinous crime of kidnapping and rape had been committed with a girl child by the accused, who is a Baba, aged about 50 years, and was known to the victim's father and used to visit her house, and therefore he must suffer for the consequences. Considering the gravity of the offence, the severity of the punishment, and the manner in which the offence had been committed, the court denied him bail. The Madras High Court recently opined that in respect of Benami transactions entered into prior to the Benami Transactions Prohibition Amendment Act 2016, coming into force on 1st November 2016, the provisional attachment under Section 24 was valid and in accordance with law. The court held that Section 1, subsection 3 clarified that the other provisions of the amended Act shall be deemed to have come into force on May 19, 1988. Accordingly, the court went on to dismiss the plea filed under Article 226, while noting that the petitioner was trying to prolong the proceedings and protract the issues on flimsy grounds. The Allahabad High Court recently decided to consider a bunch of questions framed by it on issues related to religious educational institutions like a madrasa, vis-a-vis the role of and interplay between the state government and such institutions within the framework of the Constitution. The bench of Justice Ajay Bhanot was hearing the plea of a madrasa duly recognized by the Madrasa Board and aided by the state government, seeking the creation of additional posts of teachers in view of an increase in the number of students. Against this backdrop, the court, before proceeding with the matter, asked the state government to bring in the record the syllabi or courses, conditions and standards of recognition, including the requirements for playgrounds at the madrasa and all other religious institutions which are recognized or aided by the state government. The court further asked the state government to disclose as to whether madrasas so recognized and aided also admit girl students. The Madhya Pradesh High Court has stayed a circular issued by the Reserve Bank of India on June 25th, which laid down several conditions related to urban cooperative banks. A division bench of Chief Justice Mohammad Rafiq and Justice Vijay Kumar Shukla passed the interim order on September 3rd, while issuing notice on a writ petition filed by Mahanagar Nagarik Sehkari Bank Limited, Bhopal, challenging the Banking Regulation Amendment Act 2020 and the circular dated 25th June 2021 on the ground that the same are ultra vires the Constitution. The High Court, after hearing the arguments of the petitioner bank, issued notices to the respondents and stayed the circular and ordered for the cases to be listed after 8 weeks. With this, we come to the end of today's episode. I am Taniya Pandey for LiveLaw and you're watching Courts This Week. To stay updated with the latest judgments, do subscribe to LiveLaw and click the bell icon to not miss any videos from us. I wish you a lovely week ahead.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.